Welcome to ADR TV, a whole experience.
Hello friends, welcome to HR series, proudly brought to you by Gami and Gami Group. In today's episode, I'll be discussing the difference between human resource policy and collective agreement in Ghana. This is an important topic as both human resource policy and collective agreements are critical components of human resource management practice. And it is very essential to understand the difference between the two in order to effectively manage the human resource in your institutions. Let's first of all talk about the human resource policy. What is the HR policy? The human resource policy are a set of guidelines and procedures established and adopted by an organization to govern the behavior, conduct, and relationships of its workers in line with Section 8B of Labor Act 2003, Act 651. These policies cover a wide range of issues including recruitment and selection, performance management systems, equal employment opportunities, training and development, compensation and benefits, employee relations, and disciplinary processes. The HR policy ensures consistency, fairness, and compliance with legal requirements in various areas of human resource management, and mostly vary from company to company. The purpose of the HR policy is basically to provide a framework for managing employees and ensure that they are treated fairly and equitably. In Ghana, the HR policies are usually developed by the Human Resource Department in consultation with other departments and management. These policies are usually based on the organization's values, culture, and the business strategy. The policies are communicated to employees through the employee handbook and other forms of communication, and employees are expected to abide by them. Now, let's take a look at what the collective agreement entails. A collective agreement, on the other hand, is a written agreement between the employer and the union or workers' representative. The agreement sets out the terms and conditions of employment for the employees, including wages, working hours, benefits, and other employment-related issues in accordance with Part 12 of Act 651. The collective agreements are legally binding, and both the employer and the employees are obligated to comply with the terms and conditions of the agreement. In Ghana, collective agreements are negotiated between employers and trade unions through an interest-based negotiation or a collective bargaining process. The agreements are usually valid for a specific period, usually between 1 to 3 years, and they can be renewed or renegotiated when they expire. The collective agreements are very essential in promoting good industrial relations and ensuring that employees are treated fairly and equitably. The differences between the human resource policy and the collective agreements are that while the human resource policies are developed by the employer as one of their rights as provided for in Section 8B, the collective agreements are negotiated between the employer and the trade union. The human resource policies are generally applicable to all employees in the organization, but the collective agreements are only applicable to employees who are members of the trade union, excluding management team. Another difference is that the human resource policies are not expressly legally binding, while the collective agreements are legally binding. This means that if the employer or the employees violate the terms of the collective agreement, they would be held legally liable before the National Labour Commission or any court of law. On the other hand, if an employee violates a human resource policy, they may be subjected to disciplinary action as described in the policy. In conclusion, the human resource policies and collective agreements are both critical components of human resource management practice in Ghana. It is important to note that the HR policies can vary between organizations based on their size, industry, legal requirements, and organizational culture. And while the human resource policies are developed by the employer to govern the behavior and conduct of the employees, collective agreements are negotiated between the employer and the trade unions to set the terms and conditions of employment or unemployment for unionized employees. And provisions of such can be uniquely tailored to the demands of workers in the specific industry or company. Understanding the difference between the two is very essential for effective human resource management practice and also for promoting good industrial relations. Thank you for joining us for this episode. We look forward to seeing you in the next. Until then, it's a goodbye from us.